Hi guys, and welcome to my channel. My name is Diana Romanovska and I am a certified family law specialist practicing family law in the Bay Area, California. Today I would like to talk about the length of a divorce process and the requirements to file for divorce. So the first requirement is that one spouse, petitioner or respondent, has to be a resident of the state of California for at least 6 months, consecutive 6 months before filing for divorce. That is number one requirement, and 3 months in the county. So if someone is traveling for a year and works in a different country or state, that interrupts the 6 months period. However, going on vacation, of course, for a week or two does not. So it's all about the intent of being a resident of the state before filing. So that's 6 months requirement. Then from the moment the petitioner spouse files for divorce and serves the other spouse, the cooling off period of 6 months and 1 day starts ticking. From the moment of serving the divorce paperwork, not from filing, not from date of separation, from serving the divorce paperwork to the other spouse. That's when the 6 months and 1 day cooling off period begins, which means that both spouses cannot be single until 6 months and 1 day lapses. It doesn't happen automatically. So, for example, there are many ways to terminate marital status and reserve all issues for a later time. One way to do it is, once you know that the 6 months and 1 day is coming soon, is, for example, to file a termination of marital status. It's called bifurcation status only request for order, FL 300. And then the requirement is that the moving party had served the respondent, or depending who the moving party is, it could be the respondent who files a request for order and wants to be single. Whoever files a request for order is the moving party. That party has to prove that they served the PDD, Preliminary Declaration of Disclosures, FL 142 and FL 150, Assets and Debt, and Income and Expense Declaration, to the other spouse, and that all other rights are reserved. For example, there is no issue with health insurance because, as you know, until the divorce is final, if one spouse has the other spouse on their health insurance, they have to keep it. So all rights, inheritance right, the retirement rights, all these rights have to be preserved. So that's one way to terminate marital status. Another way to terminate marital status, let's say an uncontested case that is amicable, is to prepare the entire judgment package, meaning have the forms together for judgment and marital settlement agreement, and then submit it to the court as soon as both of you exchange preliminary declaration of disclosures and you looked up the checklist. I believe it's FL 182, and file the divorce package based on your specific case, and then submit it to the court. And then even if you submit it before 6 months and 1 day, then the court can actually stamp the judgment package and declare single in future date. So you will get a judgment package back, which the judgment form in itself that you need to watch out for is FL 180. It says judgment, and it will say marital status terminated or divorce is granted on, and it will be right on top, and it will give a date. So I hope that was helpful, and I will see you soon. Bye.